Just put the proceedings on there. The date is the 31st or the 30th, of January 2023. The parties are the same as before. Presiding officer Mrs. T. Qualified, public prosecutor the J. Caesar for the defense, the L. Julius appearing for accused number 1. Advocate Matthew is appearing on behalf of accused number 2. We don't need an interpreter. Proceedings will be conducted in English. Crowd is Mdntv.
Interest and involves the party leader, Mr. Malema. Yes, thank you. That unfortunately that industrial aircon affects our recording. Sorry for that. The second application is one received by Firearm, and you are then also approved and acknowledged. Application from ENCA, approved and acknowledged. Further application by Kalei Nair on behalf of Newsroom Africa, received and acknowledged, as well as Yuri Bliffnote on behalf of SABC News, received and acknowledged. The only amendment I would like to make to the applications received is the one on behalf of Firearm, where it is requested that still photos be taken whilst the court is in session. That is not allowed. Before proceedings, after proceedings, or during adjournments, but not during court sessions. Everybody happy with that proviso, Mr. Caesar?
There's a court, please, Your Worship, but no objection to that.
Thank you. There's a further request then. Firstly, let me just read out. For record purposes, all the media houses who are acknowledged, you are fully aware of the rules pertaining to the media, so I'm not going to repeat that. Safe to say the following requests have been agreed to by the state as well as the defense. Firstly, the microphones from cell phone recordings of any kind close to the defense where they liaise with each other is private and to be removed from the bench where they are seated. That includes the bench or the top of accused 1 and 2. That is correctly stated as per our agreement. Yes, and then with regards to the witness and the cameras on that side, unfortunately, if you want, I will ask the camera person regarding the state witnesses please not to sit in my view because it blocks my view from seeing the witness, and observation and seeing plays a vital part in proceedings. What else was there? Further, the state has also alleged that there may be applications where certain witnesses who will testify, they will request that it not be filmed, but the audio evidence of that witness will be allowed. But he will warn if the case is, if it does occur, he will inform us timely. Okay. Is there anything else that I left out, Advocate Caesar?
Nothing.
Advocate Matthews?
Nothing.
Oh, sorry, Advocate Odes?
Nothing.
And Matthew. Thank you. So, since we are all ready, we may proceed.
Thank you, Your Worship. State then called in Lieutenant Colonel Mandisi Ngwadleka. Mandisi Ngwadleka. Bishop, just for record purposes, I have finalized my question in regard to this particular witness at this stage.
Just a second, I'll be with you now. Excuse me, I'm going to turn my back and head on the court. I see there's a fan here which I'm going to plug in. Sorry.
Just for record purposes, this witness's evidence was televised. The last occasion, he had no objection to the video being taken of him.
Do we have any interpreters? Oh, thank you, I didn't see. The witness, Mr. Mandisa Ngandleka, you are reminded that you are still under oath in this matter. The state has finalized evidence. Advocate Odes, I'll just check you have you finished and started and finished.
Yes.
Then cross-examination, Advocate Matthew.
This was also completed. And the state had no re-examination.
Yeah.
That's all been completed.
This is what I've got. Evidence in chief done, exhibit handed to court, cross-examined by Advocate Odes, and make mention of you according to the record. I'll just check my notes for absolute certainty, just a minute. Yes, indeed, that is the case. I wasn't sure if this is the witness where the court indicated it may still recall.
The last witness said, you said he was re-examination from Mdntv. His last question was SPA 249 and fully or real? And the witness confirmed it's a firearm in terms of the Firearm Control Act.
Yes.
And the court said, holding over questions to avoid a 186 recall.
Yes.
That was the last one.
Yes, I just want you still, that is still the position then. So at this stage then the witness, you are excused. For now we have finalized your evidence. You may stand up. Thank you. Advocate Caesar?
Thank you, Your Worship. At this stage, if I may just request a short adjournment, and I thought the court was going to have questions for this particular witness.
No, if you recall, I indicated if I reserve that, and then if it should, I will notify all of you the day in advance if it suits the witness, so that I don't delay your sequence of witnesses. That was my understanding.
Yes.
If I recall correctly.
Yes, thank you, Your Worship. Your Worship, my witnesses have just flown in. They're on their way. If I may just ask for a short adjournment until 11:15, then we can continue.
Okay. We will also arrange amongst ourselves to try to work in the load shedding loss of time.
That's correct. Thank you, Your Worship.
Thank you. Thank you. Court will resume hopefully by 11:15. Thank you.
Thank you, Your Worship. We're back on record. First, I want to apologize for not starting at 11:15. We're just trying to set up the television and everything else. My apologies for that. Thank you, Your Worship. Usually we're about to go into another phase of the evidence regarding video evidence. My witnesses are present. I just want to ascertain at this stage if there is any objections regarding the evidence that is going to be made.
Bishop, my learned friend knows, and I've made it very clear to that there is an objection. The authenticity and originality of the video evidence is in dispute. It has always been in dispute. And it's well aware of it. And Your Worship, in that right on that, to perhaps assist and guard on the friend in this report.
Please, I will just give me a second to get myself in order and know the state's application, and then I can review. And if there's a remote or you can reply, I don't know which way, is the way you reply, then objection, which way do you go?
I'm raising objections to the response and I'll reply. Bishop, a video is a photograph and film is considered as real evidence. Such items such as photographs are regarded as documents for the purposes of Part 6 of the Civil Proceedings Evidence Act 25 of 1965, and more specifically, Worship Section 34.4. There's also the established decision of Van Goben, Worship State versus Van Goben, that goes back to 1986. It's reported as 1986, Volume 4 of the South African Law, page 117. Decision of the Mattel provincial decision as it then was. Your Worship, my learned friend who wants to reduce evidence by way of video in circumstances where there's no cameraman that comes to court and says, I personally made this video. There are various versions, Your Worship, that went on the social media concerning this incident, where they differ. But over and above that, Your Worship, there isn't a person that can be brought to court to say, I am the cameraman that filmed this video. To put it practically, Your Worship, here we are in the court of law, there are cameras running. Your Worship authorized them. Should there be any dispute, each and every one of these cameramen that are manning the cameras can come and say, I manned the camera, this is what I filmed on that day. In these circumstances, Your Worship, the state is unable to do so. And they have an obligation, Your Worship, in law, to prove that a document, or in this instance the video footage, is authentic before it may be received as evidence before Your Worship. The same would apply to a particular document or a photograph, Your Worship. So my learned friend knows that he doesn't have any person to come forward before the court to say, I produced this video. Over and above that, Your Worship, and we have insight into the docket, the actual video machine has been stolen or lost subsequent to the event. So, our respectful submission, Your Worship, is that the state will not be able to prove the authenticity and originality of the video footage, which results in it not being admissible, Your Worship. It's not a question of the weight to be attributed to it. They need to pass two hurdles first, and that is to say, here is the person who filmed the video on that date. He can attest to the reliability and the fact that there's no interference. We state up front, Your Worship, that the state know that they're incapable of doing it. We therefore contest the admissibility of the video footage, Your Worship. May I approach the accused who wants to tell me something? I want to give you the internal back, Your Worship. Thank you, Your Worship. Thank you, Your Worship.
Thank you, Malema. In this particular matter, emanating from the docket, there are two possibilities of video evidence. The one appears was posted on social media, and the other one is, I think, the video which my colleague now wishes to leave evidence on. The one on social media, we have absolutely no evidence about as to who took it, where it was taken, when it was taken, etc. The one he now wants to prove, we have no evidence as to the actual operator of any instruments which recorded this video. It was down in proof of this matter as to whether one can find a distinction between it being real evidence or documentary evidence. This is the old argument which has been going on for a lengthy period of time, and which the Supreme Court of Appeal has seen fit not to resolve. So we could start with arguing about Van Goven is the right case and the state could argue that Malema is the right case to deal with this matter. The Eastern Cape, we have a decision of state versus I'll spell it to you. NTIKI. It's 2007 volume 2, also African Law Report 185CK, paragraph 20. That decision has followed state versus Rambo. What Rambo found was that before such evidence can be admissible before the court, there are a number of prerequisites. Firstly, it must be proved that this is an original document. So in order to do so, we have to have the evidence of the person who took it. As my learned colleague has now raised, we have no evidence in the document of anybody who took this particular video. And then we need to authenticate, the state needs to authenticate this video, in other words, all expert evidence to say that it has not been tampered or changed in any manner whatsoever. We also then need a witness to come and testify that in fact this video shows the actual happenings on the day in question. So somebody who was present and can testify to the fact that what we are looking at is what the charge sheet alleged. In deciding whether this is real, the documentary evidence, there are a number of sources which state that the court should look at what the purpose of this evidence is. I'll read out what it says. It appears from a number of sources, and the sources quoted are Smith and Zeffert of evidence, the Julius, that was Ramroven and this Mdntv case. The when a court is tasked with determining whether evidence should be dealt with as documentary or real evidence, the purpose for which the evidence is presented should be taken into account. If the presenter's purpose is for the court to read or listen to and interpret the contents of a piece of evidence, such evidence should be considered documentary evidence. If the fact in issue is whether the document exists, the condition thereof, or some other issue relating to the document's appearance, then it is real evidence. I can see now the purpose why the court would want to show this evidence to you is wants you to read, to listen to and interpret the contents of this evidence. And therefore it is documentary evidence. If it's documentary evidence, then the rules apply as one of the colleagues set out. It is required for the state to prove its originality as well as its authenticity, as well as a witness to establish that it is what it depicts to be. In other words, somebody who was present when it was taken. We also object to this particular evidence being admitted before the court until these steps that we take. But the only way to resolve this issue is to deal with this matter in a trial within a trial. And for my lady to make a ruling at the end of the day as to whether this evidence is admissible or not. So in essence, we are dealing with a question of admissibility. Thank you.
Just before I listen to your argument, Advocate Caesar, I just want to pose one question to the defense. From the top of my mind, I was not even aware we reached the stage of proceedings, so I'm also caught by surprise, but then you can answer at the same time. From the top of my head, I'm referring to the state versus Fury, 1994, 2 SSC on appellate division, where documentary evidence was ruled admissible, and that the key element to be answered was it relevant, and I've not heard the defense reply regarding relevance.
Well, lady, that particular decision pertained to a document written document. It didn't contain
speed camera and the calibration or from regarding the speed camera and whether it should be authenticated, and I'm just saying in the end it was ruled to be admissible and relevance played a part. So I don't know if you wish to address me on that aspect.
Yes, my lady. I think when you're dealing with a speed camera, the correct working of the camera in question is usually in dispute.
Yes.
In other words, the state has to prove that it was operating correctly,
Yes.
and that when it took the speed reading. Relevance forms are, of course, a very important part, because we wouldn't leave that evidence as not relevant to the charge. As we have in this particular matter, whether this video is relevant to this charge, that is a decision you will only be able to find. Deal with once you proceed in the trial within the trial. Whether it's relevant to the charge.
And the common principles pertaining to issues of this nature, where the court makes a distinction as to what is required regarding statutory, case law, and common law.
The problem is this. Our common law is based at the time when this type of instruments were nowhere to be seen.
Exactly.
We are now entering a phase where the law has fallen far behind technology. An attempt has been made to, bring it into line with numerous acts. The Civil Proceedings Evidence Act, the Electronic Communications and Transitions Act. There's a new one, which is which deals with data evidence, and how the proving of all of that must take place. Nevertheless, the further we get into this type of evidence in the law, the more possibility that there exists that it can be proven. I'll give an example, which is probably not a good one, but videos posted on the social network claiming to be evidence of storm damage taken in Durban on a certain day was shown that video evidence was in fact from a previous storm that happened 3 years ago. So the danger to the courts of accepting this type of evidence can never be overemphasized. And with a video such as this that the state wants to show, it is of crucial importance that before a lady accepts this evidence, it has to be shown that it is authentic, it is original, it has not been tampered with, and it is authentic evidence. Otherwise, it is so easy in modern society to be able to make a video which purports to show X, Y, Z, but in fact, that is not in fact what happened. I could even go further and tell my lady that a few days ago I was watching a program on Al Jazeera about a bomb blast. And these people showed that the bomb was detonated. 20 minutes later, everybody arrived and lay in position, allegedly having been blown up by this bomb blast. And then that incident was then distributed on the net as if it had happened exactly the same time. We cannot be enough careful. I've given my learned colleague that before the state has proved originality and that this video is authentic and has not been tampered with, it should not be shown to you.
Just for the record, I may add, I don't know what video the state is wanting to show. I live from this. Regarding the viral social video, I I've not seen it at all. Maybe I'm the only person in South Africa that I've never seen it. For the record.
Your Worship, may I answer Your Worship's question? Worship, this is dealt with expressly in the book of the learned authors Hoffman and Zeffert. Worship, and it's the latest edition at page 709, with a specific reference to the case that Your Worship refers to, that being State versus Fury, which is reported as 1994, volume 2 of the South African Criminal Law Report, page 829. The relationship said that the decision of the appellate division. There, the learned authors make the distinction very clear about the Your Worship, and they state as follows, and I quote from them, Your Worship. In State versus Fury, it is held that a photograph of a moving motor vehicle by a so-called speed camera was admissible without a witness testifying that it was the correct image, because the reliability of the camera is not an issue, and there was no dispute that it had been properly set up and operated. So that's the distinction here, my lady. If one goes back historically to the decision of Mdntv as he was at the time in the State versus Randhaven, he established the following criteria based upon the American practice, Your Worship. It's on the same page in Hoffman and Zeffert. It says, and these are the requirements for admissibility of sound recording, Your Worship. It says, 1, is showing that the recording device was capable of taking testimony. 2, is showing that the operator of the device was competent. 3, establishment of the authenticity and correctness of the recording. 4, is showing that changes, additions, or deletions have not been made. 5, a showing of the manner and preservation of the recording. 6, identification of the speakers. And 7, a showing that the testimony was voluntarily made without any kind of inducement. So if one has regard, Your Worship, with respect to the date of that matter, which was 1986, Your Worship, and things have changed since then. And those requirements were set out then. So one has regard to, as my learned colleague has stated, the capability for manipulation that we now have in all the safeguards, both in the statutes and in the practice of the courts, Your Worship. And it is my respectful submission that before my learned friend for the state can begin to introduce evidence that is clearly intended to be prejudicial to the accused, there is an obligation to establish the authenticity, originality, and reliability. And by reliability, Your Worship, I refer in essence to the possibility of manipulation being excluded. Put differently, Your Worship, the significance of the chain of custody. So one cannot come to court and say, oh, here's a video, I'm showing it, without being able to show the court under the heading of relevance, Your Worship, that this is relevant because it was formed by a reliable human being that can attest to it and can attest to the fact that it was not manipulated. Absent a video recorder or cameraman, one can never attest to the reliability of the product because one doesn't know where it came from in its original form. And that's the problem that the state has in this case. There is no particular person that comes forward and says, I recorded this footage. So it can never be relied upon because of that fundamental flaw. And that's the distinction to state versus Fury, because Fury was, this is a photograph of what was depicted having utilized a camera, the reliability of which was not an issue, and there's no dispute that it had been properly set up and operated. So you have to, with respect to us, pass those two hurdles before it goes to relevance. And that's why I draw the distinction. And I do not, with respect, believe that the state will be able to get past those two hurdles before we get to the issue of reliability. If we had, by way of example, which will be as practical as possible, a video footage that wasn't 100% clear and somebody wanted to zoom in on a particular shot in that video, and the video was not an issue, then one could rely on a photograph of what came out of that video footage, provided the reliability had been proven. In other words, if my little friend showed you a video of us in court today, somebody came and said, I made this video, and so I would not dispute that. And then somebody said, oh, if you look really, really close, you see the fan was switched on because, and then they give a of the fan and you see some movement, or do different things. But that's not the case here. Here, we're going back to the very, very fundamentals and the basic issues here on dispute. There is no person with respect to worship who says, I formed this video footage. Absent that, we say, one cannot then say, well, is it relevant? Because we don't know where it comes from. The state wants to allow it, the defense isn't admitting it, and you can, your worship, actually then view it. And I say unequivocally, the answer has to be in the negative with respect to worship. Thank you.
We request to admissibility.